provide. Those are pretty much the areas of law that I concentrate in. However, if you have a question about something and you want to talk to a lawyer, just call me. I'm glad to help. I started out as what you call a vacuum cleaner attorney. That means you suck up everything that comes in the office, whether it's criminal or personal injury or work comp, and at the end of the month you shake the bag out, hope there was enough money to pay your rent. So that's kind of how I started out, but really what I wanted to be doing was estate planning, and then I had my bankruptcy and corporate practice. So this is what I'm talking about today. This is really what I enjoy talking about the most. Now people say, well, you're talking about death, dying, and incapacity. Why do you enjoy it so much? Because my job is to protect people. I'm a walk and talk and breathe an example of estate planning. When I was 5 years old, my mom and dad did their estate plan. This was back in 1965. My dad died 5 years later from a heart attack. I was 8 years old. Back then, you couldn't leave money to the spouse because the federal government took 70% of it in death taxes. So we had a family trust, and we had a bank as a co-trustee along with my mom, so she got to keep all the money. My sisters are doing very well. They have graduate degrees. I have a law school degree. My mom lives comfortably over in University City. And so, as you can tell, this is what I know. I started dealing with the bank as a beneficiary for my mom's benefit when I was about 18 years old. And so when I went to law school, I just naturally gravitated toward this. Okay? I may seem a little nonchalant about talking about this subject, but I have to, because if I get emotional about it, that doesn't do my client service. So sometimes people say, well, geez, you're awfully cold about this. I said, no, I'm not. I'm just very determined. Okay? So, what we're going to be talking about today is death, dying, and incapacity, but just the kind of person I am, I always like to start off with something funny. Okay? So there are these two guys, Bill and Dave, and they're big baseball fans. And so they're wondering, when they die, they're going to be baseball in heaven. And so unfortunately, on his way home, Dave gets hit by a bus, and he dies, and he goes up to heaven. And St. Peter comes walking up to him, and he goes, Dave, you look a little lost. What's going on? He said, oh, well, St. Peter, I just got a question. Well, what is it, Dave? He goes, well, is there baseball in heaven? And St. Peter says, oh, yeah, we got day games, night games, double headers, you name it, we got it. Oh, phew. But my friend Bill's, he's still alive, and he's wondering the same thing. And so St. Peter says, hey, let's just get out to Heaven's cell phone and give Bill a call. Hey, Bill, this is St. Peter. Well, hi, St. Peter. Well, what's up? He said, I heard you want to know if there's baseball in heaven. And Bill says, well, yeah, I do. He goes, well, Bill, I got good news, and I got bad news. Okay, St. Peter, what's the good news? The good news is there's baseball in heaven. Well, what's the bad news? Well, the bad news, Bill, you're tomorrow's starting pitcher. So, so that's just kind of the thing. None of us knows when our number's coming up, okay? So you got to do the planning, okay? I have heard people come into my office and look me straight in the face and say, I don't give a damn about my kids. Let them handle it. And that stuff happens all the time. And so I'm here to talk to the people that say, hey, I want to find out what's going on so I can really understand it. Now, this class is nuts and bolts. I am going to move extremely fast because I have a lot of information to cover. If you have questions, please wait till the end or talk to me in private, especially if it's a family, personal kind of thing. Okay, because I'm pretty sure I will answer your question. Okay, now, as far as what we're going to talk about, we're going to talk about 3 sets of issues. Distribution issues, who gets what, when, and how, who handles what job responsibility. Then we're going to talk about the probate system in California, and then I'm just going to talk very briefly about the feds and death taxes. Right now, because of what happened last December in Washington at the very last minute, for most people, estate taxes are not a problem now, thankfully. It's the kind of thing, stay tuned every few years, depending upon which way the wind blows, but I'll talk a little bit more about that towards the end. Now, what we're going to be talking about are documents, because the only way to let somebody know what you want, if you're incapacitated or deceased, is by putting it down on paper. So when we talk about management issues during your lifetime, i.e. if you become incapacitated, we're going to talk about why I have a financial management power of attorney and why I have a healthcare directive. And then when we talk about distribution on death, we're going to talk about why you have a will and why you have a trust. Now, first thing we got to do if we're going to talk about estate planning is define what is an estate. It's everything you own. It comprises all these categories of assets, and there's several others like business interests and things like that. But these are the big ones. Now, some people have a lot of real estate, some people have a lot of investments, some people have a lot of money in 401ks, some people have a lot of personal property and collectibles. Everybody's estate's different. So if you want to go onto LegalZoom and do their cookie cutter deal, best wishes, okay? I've cleaned up their stuff too many times, okay? And so the idea is everybody has their own estate, so you want to plan for yours, okay? Now, first issue to deal with, distribution issues, who gets what? Well, it's understood if you're married and you die, everything goes to your surviving spouse. But then the issue is what happens when the surviving spouse dies, or in the case of an unmarried person, what happens when they die? First issue, tangible personal property, your stuff. Gun collections, jewelry, tools, whatever. Everybody thinks the big fights in families are over the money. Nope, it's over the stuff. Okay? Mom only has one diamond ring, engagement ring, and I got 2 sisters. Oops. I've seen families where they fight, they don't talk to each other for 20 years about this. It's like the diamond ring, it's like Solomon with the baby. You can't cut the baby in half. It either goes one way or it goes the other. Okay? Funny story. I used to do a lot of work for San Diego Police Department, and a long time ago, Dave and Tina came in to see me. And to give you a visual on Dave, he's about 6'4", 230, motorcycle cop with the big black leather boots, the short, really crew-cut gray hair, the sunglasses, the helmet. I mean, this guy pulls you over. He's not the cop you're going to start mouthing off to. This guy is yes sir, no sir, whatever you say sir. So I'm sitting there talking to him about his 401k and his house and all this stuff. And he goes, Steve, but that's not what I'm most concerned about. And I'm like, okay, so my next question is, okay, Dave, well, what is it you're most concerned about? I see, you can see how intelligent I am right there, okay? Now, he looks at me straight in the face and says, my Barbie dolls. The only thing that came out of my mouth at that moment in time was, come again. Again, my natural intelligence. There you go. Okay, well, it turns out he and his wife were big collectors of Barbie doll stuff. I guess late 60s, 70s, there was only 500 of one outfit or 1,000 of one particular doll. And this is big business. I didn't know this. You have dolls that are worth $25,000. So they have this collection worth probably $100,000. And all of their kids are into it. So they're afraid that the kids are going to start fighting over all this stuff. So the trust itself was a nice, simple trust, except for the laundry list that said, this outfit goes here and that one goes there. And they've been into my office like every 4 years updating that list because they keep buying and selling stuff. But that's what they're most concerned about. Okay. All right. Real estate and investments. I really prefer that you do, if you got kids, equal shares, or if you don't have kids, or you have kids and you have other people you want to leave it to. Percentage here, percentage there, percentage here, percentage there. I get really nervous when people start saying, I want to leave the Washington Street house here to him, and the Adams Avenue house to you. Okay? Because what happens if you sell the Adams Avenue house and you buy a Monroe Street property? When I die, what does she get? Nothing. We don't own Adams anymore. So what do you got to do? You got to go back to the lawyer and amend the document over and over. And don't get me wrong, I like repeat business. I like clients coming back to do stuff. I just don't like it when they're coming to me unnecessarily. Okay? Now, if it's like the Wisconsin dairy farm that's been in the family generation for 27 generations and you want to leave it to her, I'm all for that. But if you have stuff that is basically generic, like a piece of real estate, this or that, I'm a lot happier if you just do shares or percentages, because it doesn't matter what you have when you die. We just add it up and we value it and we allocate it, and that's how it goes. It's nice, it's clean, it's simple. And the big thing you got to remember here is if you give someone a reason to sue, they are going to sue. And so what I'm all about is setting this up in a way to limit litigation. That's the big thing. I'm very happy when people come in, we administer it, there's no hassle, and it's done. I love that. Okay? Now, special needs concerns. That has to do with Down syndrome, other forms of mental retardation, physical disabilities, quadriplegics, all those kinds of things. Okay? What special needs basically means is welfare. We're talking about Social Security disability, otherwise known as SSDI, and Medi-Cal, okay? Those are welfare benefits. They don't like to call them that, but that's, really what they are. okay? You have to be indigent in order to receive those benefits. So if you're a beneficiary of somebody's estate and they die, are you still indigent? Guess what happens to the money? It goes places you don't want it to go. So you can set up what are called special needs trusts. Basically, the idea is I leave the money for the benefit of the beneficiary, subject to rules and regulations and blah, blah, blah. The idea is you didn't give it to them, you gave it for them for specific purposes that are allowed under the law. That's the way around it. That's a whole different class, and I could go into it for an hour and a half, but just suffice it to say, if you know people with special needs kids, they need to see a lawyer, okay? Multiple marriage situation. This is the old Brady Bunch deal where he's got 3 kids and then she's got 3 kids, and we get together with Alice and Tiger and everything's all wonderful, and when we're both gone, everything goes out equally to all 6 kids. And then what happens? She dies and he finds Ms. Wonderful number 3. And what happens to her kids? Who knows? Okay? If anybody's telling you there is a perfect situation to what's called a blended family, which is the nouveau riche name for the kids from both sides on second marriages, there is no perfect situation. There just isn't. You can lean heavily towards protecting the surviving spouse or lean heavily towards protecting the kids or whatever, but there just isn't a perfect solution. That's the kind of thing where you come in, I give you the information, you go home, you talk about it, and you make a decision. Okay? People say, well, gee, that kind of stinks. Well, would you rather the other thing is you didn't even do anything in planning and then something happens to you, and what happens to your kids? Okay? That's why if anybody's telling you this stuff's perfect, it's not. All you're trying to do is just do the best you can and make the best decisions you can at the time. Okay? So, next. Oops. Go ahead. Oops. Okay, next question. When do they get it? If you don't do anything in advance, everything dumps into probate court, kids get it when they turn age 18. I don't know about you, but I was not the sharpest financial saw in the shed when I was 18 years old. Okay? So what you want to do is set up age restrictions and tiering schemes. What an age restriction basically says is, for example, until you're 25, if you need money for school, down payment on a house, starting a business, whatever, trustee has discretion to give you money for those purposes. But in terms of handing you $10,000 to go blow on the crap table in Las Vegas, not happening. Then you can decide whether they get it all at 25 or you tier it. For instance, quarter or whatever it's worth at 25, quarter or whatever it grows to at 30, balance at 35. There's multiple variations on that, but that's the basic idea, okay? Why do that? Well, number one, you give them multiple shots at the money. If you give it all to them in one shot and they lose it, no second chance. And generally speaking, people become more financially astute the older they get. So the idea is give it to them as they age and they'll do better. Also, it'll protect against an early marriage, early divorce, because a lot of times what happens is people will take the money, which, by the way, just so you know, most people don't know this, but inheritances are the only exception to the community property rule. Community property means all assets acquired during marriage. So the day you get married, your paycheck becomes community property. Inheritances are the one exception to that rule. You get an inheritance, it's yours, not your spouse's. Unless you put it in the joint bank account, or unless you mingle it with other investments. As long as you keep it separate, it stays yours. But what happens is they get married young, they get convinced, oh honey, let's do this and blah, 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 and then poof, divorce comes and bye-bye goes the money. Okay? It also protects against creditors when the kids are young too. Because if they haven't reached the age they haven't reached the attained age to get the money, creditors can't attach it. So lots of reasons to do that. Okay? I got some custom stuff that people like. The police officers made me do the drug testing stuff, so I designed that for them. Basically, test dirty, you get no money. Okay? There's variations on that, like doing rehab and all that, but for the most part, my non-law enforcement clients don't like that, unless they have a kid with a drug problem, and then you almost have to put that provision in, because if you hand a drug addict a bunch of money, they can kill themselves with it. Okay? College. I have a lot of people that are very adamant that they don't want their kids to become the late, great Christian Brando. How many of you remember who Christian Brando was? Okay, Marlon Brando's kid, big trust baby, didn't do anything with his life and finally died of a drug overdose. Okay? Most people don't want that for their kids, so they put in provision that says, if you want your money at 25, I want a degree. No degree, no money. You can still get it when you get older, but that's it. You can do variations on that too, but that's the stuff that's the people like for custom stuff. Now, next, as a result of your planning, you're going to decide who you want to fulfill the various job responsibilities. Probably the most important one is guardians of the kids. Who's going to take care of them? Healthcare agents, who's going to make healthcare decisions for you if you can't make them for yourself? Financial agents, who's going to manage your finances if you're incapacitated? Who's going to run your trust when you're gone? If we got to go to probate court, who's going to be executor of your will? And if we need to do a conservatorship, which I'll explain shortly, who's going to be your conservator? Now, I'm going to go through all these as we go through the documents, so don't feel like, hey, you're telling me all this stuff, but it doesn't make sense. It will, okay? The basic point about this is you have several different jobs to fulfill. The one person might not be the right person for all of those. For example, in my family, my sister's a registered nurse. She makes the healthcare decisions for mom if mom can't do them. I'm the financial person, so I run the trust. Okay? Now, another thing I want to point out is that, as I'm going to show you, trusts are private. There's no court supervision, which is what you want. You're trying to keep the government out of your business. So, a lot of times people say, well, I want my sister to be guardian of the kids and I want her to be trustee of the trust. The problem with that is you have the same person taking care of the kids that's guardian, that's watching the money. You don't have any system of check and balances there. She could just as easily use that money for her kids as she could for yours. No disrespect to anybody's sister, but as we all have come to know, money changes people. And big money changes people big time. Okay? So I'm an advocate of having the person that takes care of the kids be different from the person who runs the money. Okay? That way you have the person who's taking care of the money watch what's going on with the kids, and you have the person who's watching the kids watching what the trustee is doing with the money. It's really a good thing to do. I'm very conservative in that respect. Some people have overridden that and said, no, I want my sister to do it. And I'm like, fine. As long as you're informed about what the risks are and you want to go forward with it, I'm fine with that. Okay? Integration with financial planning, tax planning, and asset structure. This has to do with retirement accounts, 401ks, IRAs, annuities, all of those things. They are what I call problem children in estate planning. And the reason is that while you're contributing to these assets, the IRS is not getting paid. And as we all know, the IRS always gets paid. So you got to be careful when you're dealing with your 401ks. I'll talk about that a little bit more later in the seminar. Liquidity for survivors. This has to do with life insurance. You can have the greatest set of documents in the world, but if you don't have the money to take care of your family if something happens to you, the documents are worthless. My dad had a bunch of life insurance. That's why I'm here, okay? That's also why I'm in insurance business, because I was watching what other people were doing to my clients and I didn't like it, so I got my license, okay? So, in any event, I don't care whether you get the cheapest term insurance out there. Just get it, okay? Because I have seen things, people say, oh, nothing's going to happen to me, I'm in perfect health. Yeah, you were in perfect health until you came driving down from Verona and some drunk killed you, okay? You ever notice it's really nice people that get killed by the drunk drivers? Okay? So the bottom line is make sure you take care of yourself, right, and your family. Okay, good planning helps to avoid conflicts, delays, and expenses. The big ones are going to be probate court costs and attorney fees. Why bother? Well, good news, if you plan in advance, you get to take action and reap the rewards. Bad news, if you don't plan in advance, you have to react and suffer the consequences. I get phone calls like this on a yearly basis. So-and-so died. We don't have any money to pay the gas and the electric bill. We don't know what we're going to do. We don't know what we're going to do. We don't know what we're going to do. And they expect me to have like all the magic answers, and I don't. Okay? On the other side, 4 years ago, I lost one of my best friends. And she is a wonderful lady, And she had 4 kids from her first marriage and a second husband, and the kids and the second husband didn't really get along all that well. Okay? She died at age 51 from colon cancer. She had all her ducks in a row. I mean, that thing was locked up tight. We did everything at her dining room table. Her sister was a successor trustee. We dealt with the ex-husband. The kids were all taken care of, and the kids, 3 of the kids now are over 24 years old. They all own a house up in Temecula. The youngest one is just finishing up college and is looking forward to buying his house too as soon as he gets a job. Okay? The second husband went back to Arkansas and he's sitting on his house at his lake fishing every day, doing whatever he wants. There was no government involvement, there was no arguing, there was no fighting, there was no litigation, there was no nothing. Everything just went nice and smooth. That's the benefit of doing what you're doing now. You're not going to know, but your family will. Okay? So now let's talk about the California probate system. It's state, not federal, state specific. Every state has their own set of probate rules. So what goes on in New York, New Jersey, or Nevada, I have no idea. I'm licensed to practice in the state of California. Okay? So if you move there, I have no idea what to tell you about what's going to happen. You'll have to consult an attorney there. What I can tell you is from what I've seen, California documents travel really well. Or at least mine do, from everything I've seen. Okay? Now, because you live in California and you are a resident of the state of California, you are subject to the division of the Superior Court of the state of California. Okay? Now, if you get in a dispute with somebody, you go to the civil division. Car accident, real estate dispute, employment dispute. Divorce or custody, go to the family division. People that get arrested go to the criminal division. And then the division that we're going to talk about is the probate division. Everybody always wants to know, what is probate? It's a courtroom. What is the purpose of the probate court? It's to protect legally incompetent parties. Deceased, disabled, incapacitated. So if your loved one or you or one of those three, you or your family goes and sees the probate judge. Now, first thing everybody wants to know, if my spouse died, do I got to go to probate? The answer is no. If you're married and you're asked to be the community property, which is all property acquired during marriage, or held in the form of ownership called husband and wife as joint tenants, there's no probate at the death of the first spouse. That obviously begs the question, well, why is probate necessary in the first place? And the answer to that question, excuse me, has to do with a concept that I've termed signature authority. I've never heard anybody define any more clearly than that, so I just picked signature authority. If you think about it, there's two ways that you could voluntarily transfer a property from you to somebody else. You could either hand it over, like I'm handing this woman the clicker, or you sign it over, right? Everybody says, wait a minute, what about point and click on the internet? That's an electronic signature, isn't it? You're checking the little box that says I have agreed and blah, 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 blah. Okay? So when you sign your name, what exactly are you doing? You're voluntarily transferring something from you to somebody else. You're either transferring money in return for goods and services, like at the grocery store or the electronic store or whatever, or you're transferring services in return for money, like here at work. You probably sign an employment agreement somewhere along the line. So you give services, they give you money. The way that all happened is you sign your name somewhere. Whether it was a check, credit card, slip, purchase and sale agreement, whatever. What you did when you signed was, I hereby voluntarily transfer this in return for that. Because look at this check. Everything looks great. But if there's no signature there, is that check worth anything? No. That's what binds you, your signature. So always keep that in mind. That's why everybody says it's not a done deal unless sign on the dotted line. Okay? So that's voluntary transfer. Let's talk about involuntary transfer. Who in the state can substitute their signature for yours and transfer your assets without your consent? The only one who can do that is a Superior Court judge via his or her signature on a court order. I'm sorry, Mr. Fly, what's your first name? Martine. So Martine's driving down the road, runs over little Mr. on Mr. Motorcycle. Mr. Motorcycle gets upset, gets hurt, goes to the doctor, then goes sees the personal injury lawyer. Personal injury lawyer sues Martine. Judge says, Martine, it's your fault. Pay Mr. Motorcycle $10,000. But what does Martine say? She says, it was not my fault. I'm not paying a dime. Can you do that?
Sure.
Okay. So what can little Mr. Motorcycle do? Well, he can get a court order signed by the judge to either garnish her wages or levy her bank account. What a court order is a piece of paper signed by a judge. That piece of paper signed by the judge shows up at payroll here, and what do? They take the money out of her paycheck and give it to Mr. Motorcycle. Okay? So in effect, what happened? The judge's signature was substituted for hers to move the money to little Mr. Motorcycle. Excuse me. So we know if the way you voluntarily transfer property is by signing something, and we know the only way property can be taken away from you involuntarily is via a signature on a court order. I have a question for you. Have you ever seen anybody in a coma or in a casket sign their name? Probably not. Good morning, Your Honor. Welcome to the probate court. I don't care what anybody tells you. Probate is nothing more than a really cumbersome and overly legislated asset transfer procedure. The bottom line is you can't sign for yourself, and the only one who can substitute for you is the judge. That's why back when we talked about community property and joint tenancy, there was no probate at the death of the first spouse. Why? Because when you're talking about community property and joint tenancy, how many signers are we talking about? Something happens to one, survivor can still sign. But now we have a single person there, either unmarried, divorced, or widowed, and they can't sign. Now we need the judge. Okay? So everything I'm going to talk about from here on out is talking about putting documents and legal entities in place so you or your family doesn't have to go see the judge. So, first thing, let's talk about incapacity and disability. If you become incapacitated, we have to go to court and get a conservatorship appointed over you. Conservator of your person means who takes care of you physically, what doctors you go to, where you live, what clothes you wear, etc. Conservator of your estate is who manages your money. You can have two separate people, one for the conservator for the person and one for the conservator for the estate, or you can have one person do both jobs. It's a matter of personal choice. Problem with conservatorships, they are expensive, okay? And court filing fees and investigative fees, right at the beginning, you're talking $1,500. Forget, not even include talking attorney fees, okay? You're in the system, okay? That means the wheels of justice turn slowly. In this county, we used to have 4 probate courts, then it went down to 3, then because of the budget cuts, they just closed the North County Court, probate court, and we're down to 2 judges that are doing the job that 4 judges used to do. So if you think court gets delayed before you were dealing with this, it's even worse now, okay? And it's emotionally traumatic. You're basically traipsing mom into court telling the judge, mom's incompetent. Mom's not gonna like hearing that. I don't know if any of you have ever had any experience with people suffering from Alzheimer's and dementia, but one of the first warning signs is anger. And you start talking about taking away their freedom and doing things for them, and look out. You start putting a conservatorship in the middle of this, it is not a fun place to be. I don't know any kids that are conservators of their parents that enjoy it. Okay? It's just not a good place to be. So the way you stay out of this is to do the 2 documents I talked about at the beginning. And if you look here on the, right inside the handout, they're right there. Okay? And by the way, the handouts I think are the important handouts for you to take away that'll hopefully jog your memory when you leave. Okay? All right. Now, first document is called the Durable Power of Attorney for Financial Management, otherwise known as a DPA. Okay? What is a power of attorney? Power of attorney says, I give Martine the right to sign my name. That's what a power of attorney means. Okay? Now, first thing you want to know about a power of attorney is, when I die, it dies with me. You cannot have power of attorney for a dead person because they have nothing to give you at that point in time. I hear it all the time, Joe died, but I got power of attorney. No. When Joe dies, we look to his will and his trust to see what to do. But while you're alive, powers of attorney are very useful, okay? Now, there's that magic word up at the front, durable, because a regular power of attorney, in order to be effective, has to have 2 things. Number 1, when I do it, I'm competent and I'm alive. But if I become incompetent, you can't even do a durable power of attorney. You can only do a power of attorney when you're competent, okay? So that's why you want to do them in advance of mom getting sick, okay? So the first thing is that I have to be competent and I have to be alive, okay? But if you have a durable power of attorney, the only thing that matters is that when I did the power of attorney, I was competent. If I gave Martine durable power of attorney and I later became incompetent, the power of attorney is still good if it's durable. That's what's different from a regular power of attorney. When I go incompetent, it's gone. But that's why the legislature put in the durable power of attorney law. So as long as I was competent when I did it and I'm alive, she can use it. Doesn't matter whether I have Alzheimer's, a quadriplegic, whatever. Okay? Now, you can make a power of attorney general, which means you do everything. My 401k, my checking account, my house, my life insurance, my personal property, whatever. Or if you want, you can give somebody a limited power of attorney, which means you can sign my checks and that's it. You can't touch my house, my 401k, nothing. That's it. Okay? You can have it effective today, so I give you a power of attorney right now. You can go to Wells Fargo right now and get all my money. You can beat my wife there. All right? Or you can make the power of attorney springing, which means I name you today, but you can only sign for me if and when I become incapacitated. And then it springs into action. That sounds like a really wonderful thing, isn't it? I mean, yeah, can't sign for me until I'm incompetent. What's the problem with that document? How do you determine incompetent? I have seen these ones that have getting 2 doctor's declarations. Can you get your doctor on the phone? Maybe. Okay. So the problem is that the determination of incapacity, because even like mine, I have one that says I pick 3 people, so I pick you, you, and you, and plus my treating doctor. I call it the gang of 4. If 2 of you say I'm incompetent, then she can sign for me. Okay. But even that's difficult because the banks look at the declarations. Were they notarized? Were they not notarized? Is who, you know? Okay. And while this all is going on, she needs to get to the bank because the nursing home needs a check to get me checked in there. And the nursing home isn't saying, well, you know, that's fine. We'll take your mom now and you can give us the money next week. Huh. No. They want my cash on the barrel. So that's why there's no perfect solution for this. And the risk for fraud and abuse is huge with this. You're giving someone the right to sign your name. Okay? Right. Elder abuse is the second fastest growing crime in the United States, second only to identity theft. And it's the most disgusting crime around. Okay? Because usually the victim and the perpetrator know each other, and the victims don't want to come forward because that's the only person that's taking care of them. And when you get elderly, you could feel like that you're the, you know, that abusers, one of the things that abusers do is they try to get their victim to feel like it's their fault. And that's what happens. When seniors get old, they get frail and they're afraid and they don't know what to do. Okay? So I think it's like, I heard a statistic like about over 67% of elder abuses cases never get prosecuted. Either because the victims don't want to testify or that the DA's office doesn't have the resources to prosecute all the cases. So you got to be careful. This is just a really dangerous document, but if it's drafted properly and under the guise of an overall estate plan, it's good. It's a good thing. Now on the medical side, there used to be an old healthcare power of attorney and a separate living will. Everybody's heard of those. They don't know exactly what they are, but they heard of them. In California, excuse me, they don't exist. They were consolidated in the Advanced Healthcare Directives in 2001. I just call it the medical directive. It's easy to remember. Okay. So what does it do? Well, it did what the old does. It does what the old 2 did and adds a few things. First thing, healthcare agents. I can't make healthcare decisions for me. You make them for me. If you can't, then you. And if you can't, then, well, I don't know. Maybe. Okay? Now, life support. Do I want to be on life support or not on life support? I have seen people write 3-page diatribes about, well, if this happens and I'm in a coma and this happens, but if it's a long and degenerative condition, if it's this kind of condition and blah, blah, blah. And I just look at them and I go, what? Because last time I checked, nobody knows what's going to happen to them. Okay? And I'm very pragmatic. I'm sure as you can all tell, I'm kind of a nuts and bolts guy. If you can't explain it to me in 3 minutes or less, I'm not interested. Okay? And so this is the way I see the document. You either give your agent discretion when to let you go or you don't. It's that simple. The whole question is, do you trust your agent? I mean, I've done over, God, I don't know, 1,500 medical directives. I can't remember more than 5 times where people said, I want to stay on, people said, keep me on life support. Everybody they trust their agent and they let them decide when the right time to go is. If you don't trust anybody, don't do it. Okay? Now, pain management. I don't quite get this, but it's in the document. And what it says is, you can restrict pain management techniques if I'm terminally ill. Okay? I've never had cancer, but from people I know, I've talked to that have cancer, they said it is extremely painful. Okay? So I don't know anybody that's going to restrict pain management on terminal illness, but it's there if you want to. Okay? Last thing is organ donations, and this is a 2-part question. Question 1 is, do you want to donate all, some, or none of your organs? If the answer is all or some, then question 2 is for what purpose? And there's 4. Transplant, pretty straightforward. Take them out of you, give them to somebody else to save life. Number 2 is therapy. And I think what that has to do with is bodily fluids like blood and things like that for therapeutic kind of purposes. I'm not exactly sure. I've never really gotten a straight answer on that. Excuse me. Number 3 is research. That puts you in the university laboratory with Igor. Anybody remember that movie?
Yeah.
What movie?
No,
There you go. No, it's Frankenstein. There you go. Okay, and number 4 is education. That sends you to med school to be a cadaver. Some people are okay with transplants, some people are okay with all of them, and some of the people say, I don't want to do any of it at all. Bottom line is, it's your body. You decide. Because at the hospital, when mom doesn't have a medical directive, and they're telling the kids it's time to shut the machine off, then they come asking, do you want to donate organs? That is a terrible thing to have your kids figure out on their own. It's absolutely terrible. Okay, so make sure you decide. Okay, now, even if you don't want to hire me or any other lawyer, you can get this document online and do it yourself. Okay, so if you don't want to do your whole estate planning, at least do this and give your family a whole lot of peace. Okay, now. Let's talk about what happens when either the surviving spouse dies or in the case of an unmarried person when they die. If your gross probatable estate's less than 150 grand, summary administration, piece of cake. If your gross estate's more than 150 grand, full-blown probate. That obviously begs the question, what does gross and what does probatable mean? Gross is where everybody gets caught. Gross means we add up the value of all your stuff, but we don't deduct your debts. Why? Because we're trying to figure out whether you go into little court or big court. So if your house is worth 500 grand and your mortgage is 450, your net worth is 50. Well, what's your gross probate value? 500. Okay? That's why I always tell people, general rule of thumb, got 150 grand, you own a home, get a trust. What probatable means basically is the asset doesn't have a beneficiary designation on it like life insurance and 401ks do. Because if it has a beneficiary designation on it, it's already set up with the insurance company to pay it to whoever you name to go to. So probatable assets are basically cars, bank accounts, real estate, investment accounts, business interest, personal property, those kinds of things. And I'll talk a bit more about probatable assets as we get into trust funding at the end. But the basic idea is, if you own a home, or you got 150 grand in investments, you want to get a trust. If people try to tell you it's more complicated than that, it's not. Okay? Now, next question, did you do a will? If you did not do a will, then you died what's called intestate, which means you did not exercise testamentary capacity. Testamentary capacity means I decide where my stuff goes when I die. You do it in one of two ways. You do a will or you do a trust. If you haven't done either one, then the state law of intestate succession kicks in through the probate system. If you did do a will, then we administer your will through the probate court. That brings us to myth number 2. I have a will, so my estate will not have to go through probate. Wrong. All wills go to probate. Only question is, are you going to little court or big court? Why? What's a will? Piece of paper signed by a dead person. They all say last will and testament, right? But how do we know which was the last one and which was the first one and which was the third one? All wills have to go to court to be proven up. I can't take Martine's will down to Wells Fargo and say, give me her money, because what do they say? Sorry, I need a court order. Okay? So, if you didn't do anything, then we go through the intestate succession statutes, which means you didn't control your distribution, you did not nominate guardians for your kids, which is a big boo-boo, and it's generally more costly because a lot of times we have to get investigators involved to find out where your stuff is, or forward the mail and wait 6 months, and all kinds of stuff. If there's one reason where I really say to do a will, if you have kids. Okay? Most people don't realize this, but if you want your best friends to be guardians of your kids, if they're not nominated in a will, it's not happening. Okay? Family first, then the state. So at a minimum, you're going to do a will. And basically a will says this. I nominate you as executor, I nominate you as guardian, and I leave my stuff to so-and-so. That's all a will says. May put in their burial instructions if you want, but that's basically the long and short of what a will does. Okay? So, what happens in probate? Well, California, we have probably the most complicated probate system in the United States. So what happens, you go through the period of administration where you file a petition in the original will with the court. If people want to contest the will saying it was by fraud or somebody put a gun to your head to get you to make the will, that's the time when you have will contest. If the judge approves of the will, he admits it to probate court and appoints the executor, and the executor gets a court order called letters testamentary. Nice fancy name. All it is a court order authorizing the executor to administer the estate. So the executor does what you would think an executor does. They go get a tax ID number from the IRS, open an estate bank account, and start marshaling and liquidating all the assets. Send notices to all the creditors to get paid, then negotiate and pay off all the debts, inventory and appraise all the assets, which gets expensive. Then finally you do an accounting, and you submit the accounting to the court, and the judge says, okay, I approve the accounting, and here you go, kids, here's your piece of paper saying you own all the stuff. In return for the piece of paper signed by the judge, here are the issues. Number one, it's a public proceeding. Anybody who wants to know your business can go to the court and pull your file. It's public record. Now, you may not care because you're gone, but you might want to care because the names and addresses of your beneficiaries and kids are in that court file. There are unscrupulous business people that go looking for beneficiaries to sell them stuff and separate them from their new money. Okay? Now, why do criminals do that? Why? Because they're easy marks. They're probably much younger. They probably don't have as much experience with money. Okay? And especially a lot of money, and they're generally acting on a lot of emotion because they just got it. Okay? So one of the nice things is I'm going to show you about doing trusts. Everything's private. It's a big advantage. Okay? Now, it's expensive. The attorney and the executor get a matching fee based on the gross value of the estate. So if your house is worth $500,000, I pick up about $13,000. The executor picks up about $13,000. And depending upon what kind of assets you have, probably $2,000 or $3,000 in court costs. So if there wasn't that much equity to begin with, there probably isn't that much money left over for the kids. And if there isn't enough money cash to pay, we got to sell off the house. So if you wanted the kids to live in the house and we need the money to pay the expenses, the house gets sold. And it's time consuming. It takes 9 months to 2 years longer if contested. Okay? And now with all the court delays, it's getting longer, unfortunately. Okay? I took over a probate that had been in the system since 1994. I finished it 3 years ago. I got it 4 years ago. It took me a year to clean it up. Okay? There was fraud, misappropriation. I mean, you could have written a movie. You could have, it could have been a screenplay. I mean, it was just unbelievable. But that's what happens when this stuff ends up in the system. So you kind of want to stay out of it. So what do people do? They don't want to hire a lawyer. They're going to do it themselves. And so they say, you know what? I got 3 kids, and I'm going to put my house into my oldest son's name. Well, so they do a deed transferring it from, Steve to Steve and Billy, joint tenants. Sign the deed, notarize it, record it at the county recorder's office. What did I just do? I just created a partnership, didn't I? So if I want to sell it and go spend the money in Vegas and Billy says, no, Dad, when you die, I'm moving in, who wins? Billy. Takes 2 to tango. Suppose Billy runs over a little old lady. He now owns half a house. Creditors can go after that. Okay? And when I die, Billy gets the house, right? Now, I told him to make sure he gives his brother and sister a third of the house. But what happens to the other 2 kids? In automatic case of amnesia, Billy forgot. It's not legally required to do anything. Okay? I call this a poor man's trust. It's a really bad, and there's capital gains problems with this, but that's a discussion for another day too. Just suffice it to say, if somebody says put something in joint tenancy with somebody, be careful. Okay? Now, so what we're going to talk about now is the good planning. And it all starts off with a revocable living trust. It's the way to avoid probate and keep control of your assets, which is what you want. You want to maintain control of all your stuff until you die, and you want to keep the government out of your business. That's the best of both worlds. Now, everybody gets caught up in these words, revocable or irrevocable. It gets really confusing. Okay, but it's not. What revocable means is I can change it anytime I want. Well, why would I want to change my trust? Well, let's say that I said, you know what, let's assume I'm single today, okay? And I say, you know what, when I die, I want all my assets held in trust for my kids, and Martine, I want you to be the trustee to take care of the money for my kids. Sign it, notarized, everything's cool, everything's clicking along. 6 months later, I'm talking to Jennifer, and Jennifer's telling me, hey, Martine's doing really well out of Verona every night. Oh. So since my trust is revocable, I can do an amendment, that takes Martine out and puts my friend Joe in. Unless there's a really good reason you want your trust to remain revocable. Irrevocable means exactly what it says. You cannot change it. Irrevocable trusts are for complex, large estates, and it generally involves tax planning to avoid paying the government a lot of money in taxes. Okay? If people try to sell you on irrevocable trusts, they're probably using fear, saying, oh, somebody can sue you and take your assets. And then every time somebody brings that to me, I say, okay, all right, well, what are you going to get sued over? Are you in the tobacco business? Are you running liquor in between interstate? Are you out shooting people on your front lawn? Okay, do you regularly drive drunk with a gun in your hand? What are you going to get sued for? That's usually the thing. People say, well, I have a rental property. Okay, so did you put your rental property in a limited liability company or in a corporation? Or did you get a big umbrella liability policy from your property casualty person? There's nothing for you to really worry about. All these irrevocable trust guys are trying to do is get your money and create a whole set of problems with you that you're not going to want. I've been practicing estate planning for 21 years. I was a CPA before that. I understand all these schemes. They call them advanced estate planning techniques. I call them revenue generation machines for the attorneys and the accountants, because that's always what happened. When I started out, I worked for a litigation attorney, and all he did was sue lawyers who pulled these games. And what happened was the lawyer would set this thing up, and then 2 years later, the IRS would put in a regulation shutting down what they did. And guess what happens when the IRS shuts you down? Penalties, interest, and taxes. And very unhappy people, okay? So when you do your planning, you want to keep it revocable while you're alive. The only time you want it irrevocable is when you die, because that's my stuff. When I'm gone, this is what goes down. And if you don't like it, that's too bad. That's the way it is. Okay, so that's the big picture, okay? Now, if people are telling you trusted for creditor protection, I already told you they're not. They're for estate planning. If you have issues with creditors, that's what LLCs, corporations, and liability policies are for. Now, how does the trust work? Well, what we're going to do is create a living entity separate and apart from you that has the ability to carry out your wishes whether you're alive or dead. If you think about what the problem is, the solution is very simple. The problem is that I'm the only one who can sign on my stuff. So when I die, everything I own is going to probate court. Okay? Well, if I don't own anything when I die, then there's nothing to go to the probate court, right? But if I don't own it, who does? My trust. See, we're all persons. We're natural persons. But there are other entities that are persons. Pacific Mechanical is a corporation. It's a person you work for. You get a paycheck from it every couple of weeks, right? Okay? Limited liability company is a person. And a trust is a person. So what you're going to do is you're going to set up this trust, this person, and it's going to own your stuff. Now, you're in complete control of it, but you're not it and it's not you. You're two separate entities. So the idea is when you die, it's still around doing what you told it to do. That's the big picture, okay? Now, how does this all work legally? Well, it all works because we're able to separate your ownership interests. And as you sit here today, you have two kinds of ownership over your stuff. You got the beneficial ownership and you got the legal ownership. There are so many attorneys who don't even understand this, so hopefully you guys will get this and you'll know something lawyers don't. There you go, okay? Beneficial ownership means for whose benefit is my house owned? Mine. I eat there, I sleep there, I drink there, I party there, I watch football games, I raise my kids. That's about it, okay? I'm not touching the beneficial ownership of your house. It's yours before you do the trust, and it's yours after you do the trust. What I'm going to screw around with is the legal ownership of your house. The legal ownership means the form of title that you choose to use to show the rest of the world that that's your house. Well, what are your choices? Well, if you're married, I bet your house is either husband and wife as joint tenants, or husband and wife as community property, right? Or it could just as easily be Jennifer, married woman, has her sole and separate property. Steve, an unmarried man. Martine's corporation. Rick's LLC, and then we're going to add one more onto it, Smith Family Trust. Okay? That's the big idea. Okay, now, how does this work? Well, what I'm going to do is separate, I got to stay here for the camera. What I'm going to do is separate what you do now into 3 separate job titles. So with regard to your house, you actually wear 3 hats. You are the owner of your house, the person who's on record title, right? And you are the manager of your house, the person who signs on the dotted line, whether it's a kitchen construction contract or a line of credit or whatever. And you own and manage your house for the benefit of, you. Okay? Well, guess what? In the trust, there are 3 job titles as well. The owners of the trust are called the settlors. You'll also hear the term grantor or trustor. I like settler because it's easy to remember because you're settling up your family affairs. The only one that can change the trust are the settlors. So by definition, when the settlors are dead, there's nobody around that can change the trust, then the trust becomes irrevocable. Make sense so far? Okay. And while you are alive, you are also the trustee or trustees of your trust. Trustee is a fancy name for manager. Whoever is trustee holds the pen and has signature authority to sign on behalf of the trust. Why were we in probate court? Because there was no one who had signature authority to sign for you, right? Okay? So, while you're alive, you're trustees of your trust. And you own and manage your trust for the benefit of you. So, we sign this trust, we notarize it, it's now a valid legal entity. And then what do? We fund it. I'm going to talk about trust funding in about 5 minutes, but bear with me. I want you to go to the last page of your handouts, and you're going to see it's called the grantee. When you bought your house, so-and-so granted the house to you. Husband and wife is joint tenants, husband and wife is community property, so-and-so, an unmarried person, whatever. Well, we're going to do another grantee. And what does it say? It says, John and Susie, husband and wife is joint tenants, hereby grants ownership of the house to John and Susie, trustees of the public family trust dated blah, 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 blah. They sign this deed, we notarize it, we ship it off to the county recorder. Legally, when everything's all said and done, who owns the house? Trust. Okay, but who owns the trust?
You do.
John and Susie. So as far as the outside world is concerned, has anything really changed? No. Before they were owning it as joint tenants, now they own it in their trust. And if one of them dies, it's exactly the same as if a joint tenant died. Because if a joint tenant died, what do you got? The surviving spouse. Owner, managed beneficiary, same thing. Surviving settlor, surviving trustee, surviving beneficiary. Why? Because the problem's not when the first spouse dies, is it? It's when the second spouse dies. So now, in effect, when the one spouse dies, it's now exactly the same as if we have an unmarried person who set up a trust, because you have a one-person trust, settlor, trustee, beneficiary. Okay? So we create the trust, we put everything into the trust, and then the trust says who gets it, and they got to go to college, and they got to do a drug test, and blah, 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 blah. But the key difference in the trust is you name a successor trustee. So, for example, my wife and mine says we're co-trustees. If something happens to one of us, the survivor is the sole remaining trustee. If both of them are gone, then my sister Marlene becomes the new trustee. Okay? So when both of us die, what happened? Marlene becomes the new trustee. She's the successor trustee. Okay? That's the big difference. So what happens? What did I do? I just handed the chosen pen to my sister Marlene, my chosen fiduciary. Successor trustee has what? Legal signature authority to do exactly what I told her to. Why were we in probate court? Because there was no one around with signature authority. We just created a trust where the successor trustee has signature authority to act. Therefore, you don't need a court order. There's no filing. There's no public disclosure. Your privacy remains intact. Administration is quicker and easier, and it's tens of thousands of dollars cheaper. Okay? So what do? We said while we're alive, we're settlers, trustees, beneficiaries. When we're both gone, no more settlers, trust becomes irrevocable. We say who the new trustee is, which is my sister, and who the new beneficiaries are, my kids. Make sense? Okay? So, we put everything in the trust, then we die, everything goes to the kids except for what? We've been talking about the state of California for the last 20 minutes. Who'd we forget? Your friends and mine at the federal, at the IRS. So they say, when you die, we want death tax. They call it the federal estate and gift tax system. It's death tax. Okay? It's a wealth accumulation tax, and it's based upon your net worth. And people don't realize this, but net worth includes proceeds of life insurance. People say, no, Steve, you're wrong. Life insurance is tax-free, isn't it? Yeah. Income tax-free. Death tax-free. So they say, oh, that's great that you planned for your family. And when 10 years ago, when the limit was $600,000 per person, it was a big problem. But now the limit's $5 million per person, so go get all the insurance you want and come and see me too. Okay? Now the estate tax system includes any and all assets. The estate tax code is incredibly complicated. So if you think you're going to give away stuff 6 months before you die, they look back at all transfers within 36 months. It's just, the estate tax code is like this thick. And the income tax code is like this thick. Why? Because there's a lot more money involved. You got rich people with lots of lawyers and they fight. And they lobby and they get all the laws passed they want. Okay? So it used to be, you had to have what's called an AB trust. And I'm just going to go through this kind of quick so you can get an idea how sneaky people were 35, 40 years ago. Okay? Let's say you guys are married and your net worth is $10 million. That means under community property law, $5 million is husband's, $5 million is wife's, right? Okay. Well, if I got $10 million, my wife and I have $10 million, and I die, I leave everything to her. She's got $10 million, and the exemption's $5 million. So that means $5 million goes straight to the kids, and what happens to the other $5 million? It gets taxed at, now the rate's 40%. Okay? So what you used to do back in the day was you'd set up an AB trust. So what happens is everything's in one big trust, and when the husband dies, his money goes here, and the wife's money goes here. Then when they both die, when the wife dies, everything goes to the kids. So basically what happened was the husband left his money to the kids, but it's in trust until the wife dies. So the wife has use of this money. There's restrictions on it and stuff, but the idea is husband left $5 million to the kids, wife left $5 million to the kids get $10 million, IRS gets nothing. You don't really have to do this anymore because they have this thing called portability, which the rules are giving me a headache on right now, and stay tuned. It's like, yeah, and people say, well, what do you mean by that? Oh, just wait till Obamacare kicks in and you'll understand. Okay? Now, trust funding. A trust is only as good as what you've put in it. If you fail to fund your trust, it's useless. This is where all the mistakes are getting made now. Okay? I have people coming to my office with these beautiful leather-bound notebooks and parchment paper, and God, it looks beautiful. I'm like, how much did you pay for that? Oh, $2,500. Oh, that's nice. Can I see the deed to your house? To your parents' house? The what? The deed. See, if your assets are not in the trust, where are they going? Okay. I get more probates now for people that didn't fund their trust than I do for people that didn't do documents in the first place. Why? Because nobody ever teaches anybody what to do. Okay? A lot of lawyers' mentality is keep people in the dark, you make more money. Okay? I know that sounds kind of mean, but that's the way a lot of people operate. I have an empowerment mentality, which is the more people I educate, the more people refer. That's my thinking on it. Okay? So what happens is, you have all these different kinds of assets, and you got to figure out how to get them in the trust. And it gets confusing. So when people get confused, what do they usually do? Nothing. So what I did was I boiled it down to one question. Okay? And that question is, whatever asset you're looking at, the question is, does it have a beneficiary designation on it, yes or no? If it has a beneficiary designation on it, you modify the beneficiary designation. If it doesn't have a beneficiary designation on it, you got to change the name on the ownership. Okay? First of all, what is a beneficiary designation? A beneficiary designation is a contract between you and a third-party custodian, life insurance company, 401k custodian, IRA, annuity company, whatever. And the contract says that when I die, they pay the money to whoever I listed on the beneficiary form to receive it. Okay? Well, if there's a beneficiary named when I die, do we care who owns it when I die? No, the only thing that's relevant when I die is who gets it. So on all these assets, 401ks, IRAs, annuities, life insurance, credit union accounts, blah, 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 you don't have to change the ownership. All you got to do is play with one simple form that takes 5 minutes to fill out. You can even do it online now. A lot of the companies have things where you can change beneficiaries online. The big thing is just authenticating who you are. And so you have to print it out, and you got to put it in a number 10 envelope, and you got to get your priest to swear by it, put it in the mail, and then everything's wonderful. But in the big scheme of things, that's about as difficult as it gets. Okay? So, what do you do with beneficiaries? Okay. Well, normally there's two: primary, contingent. Primary beneficiary means if I die, who gets it? Bingo. Contingent means, and you'll also hear the term alternate or secondary beneficiary means the exact same thing. That means if she's dead, who gets it? She does. Okay? So what do you do when you have a trust? The short answer is keep the spouse as the primary beneficiary for everything. I get arguments from lawyers about this all the time, but just do it. Okay? Because it's simple. Spouse gets everything, and if something happens to the spouse, make the trust the secondary beneficiary, the contingent beneficiary. The idea is while we're alive, we keep everything together, and if something happens to both of us, then everything defaults to the trust. It's the easiest way to do it. There are some problems with 401ks and IRAs if you send it to the trust rather than to the kids, blah, blah, blah. But hopefully they're going to fix all that stuff in the next couple of years. But I would just assume you send everything to the trust, because people say, well, if I send it to my kid and my kid's 20 years old, he can blow all the money. I'm like, yeah, you can. Because the idea is if everything defaults to the trust, then the trustee is taking care of the money, and that's why you did the whole thing in the first place. Right? So what about stuff that doesn't have a beneficiary designation? Real estate, investment accounts, bank accounts, personal property. Got to change the name on the ownership. With real estate, you do deeds. I do those for my clients all the time. Okay? What you got to watch out for is if you refinance. Why? Because the banks don't like loaning money to your trust. They want to loan it to you. So they make you do a deed reversing this. So you as trustees hereby grants to you as joint tenants. They record that. Then they record their new mortgage, otherwise known as a deed of trust in California. Then you would think they would be kind enough to do another deed just like this, putting it back in. They don't. I've gone to clients that I did trust for 20 years ago to do a review, and I asked a stupid question. Is your house still in your trust? Of course it is. Why wouldn't it be? Well, did you refinance? Oh yeah, like 4 times. The first time it was like 6, and then it was 5, and this last time it was 3 1/4 and no closing costs. And then I go online and I look up and I see, sure enough, there was a deed taking it out. And there wasn't one going back in, and their faces just go white. Because what happens when you're at escrow? You're signing like 72 documents in 45 minutes and signing it. I just did one. I'm a trustee of a trust for one of my clients that passed away. And I'm selling a house, and I'm like, I don't even understand these disclosures, and I'm a lawyer. And you're sitting there, oh, it's so easy, just stick that in front of you and sign, oh, thank you very much, next document. But that's what happens. So I always tell my clients, if you refinance, just call me, I'll walk you through it, okay? If you're not my client and you want to call me, go ahead, call me. Okay. All right, now, investment accounts, mutual fund brokerage, internet accounts. What usually happens is you have to go online and open a trust account. They have individual accounts, joint accounts, and trust account. You're going to open a trust account, and they're going to say, what kind of trust? Revocable. Ding, check the box. Then you fill all the information in, and that's it. And then what you do is you sign an account transfer form. What the account transfer form does is it moves the money from the joint account over into the trust account. I like to put it like this. You're moving the money from one warehouse to the other warehouse. Because there's no capital gains involved, there's no taxes. All you're doing is changing it from one warehouse to the other. You're having it from the old joint and you're putting it in the trust. It's that simple. On bank accounts, you're just going to change the name on the account. Do you have to reorder checks? No. I don't care what the check says. Most people, oh, you get a check from, a trust. Oh, you must have money. So I don't care if your checks just say Joe and Mary on them or Joe or whatever. I don't care. Okay, it means nothing. The only thing that matters to me is who's on the bank statement. That's it. Okay? Now, last question. Do you need a will if you have a trust? The answer is yes. It's what's called a pour-over will. If nothing's going to probate, you don't really need the will for anything, right? Well, the main purpose of a will when you have a trust is that's a document that nominates the guardians for the kids. Some attorneys want you to nominate guardians in the trust, and that is just like felony stupid. Because the document that nominates the guardians has to get filed in the court, because that's what the judge reviews to make his legal determination on guardianship. So if you name it in your trust, you have to file your trust with the court, which means you just took your private family trust and turned it into public record. So you have a very simple pour-over will. I call it a skeleton trust. It basically says, Martine, I name you as executor. Jennifer, I name you as guardian. And third, I leave everything to my trust if I screwed up and didn't put something in it like I was supposed to. Okay, it's a pour over will. Okay, give you. How are we doing? Everybody okay for about another 5 minutes?
Yeah. Yeah.
Okay. When I first started, I had a really wonderful couple, and they had 3 kids. They had 2 lovely girls and 1 son, as I call him, Charles Manson Jr. He was doing 10, I'm serious, he was doing 10 plus in state prison for armed robbery and all kinds of stuff. And mom and dad were like not amused at all. So they left him 10 grand and left everything else for the girls. Okay? And then as I found out, a couple of years later, they bought a condo up in Mammoth because they really liked it up there. They didn't put it in their trust, they just put it in joint tenancy and they forgot about it. Okay? Then mom died, then dad died, the girls came to me in a panic. They go, it's not in the trust, it's my brother getting a third. And I said, can I see your mom's will? It's the same will I did. Still good. Never failed. What does the will say? It says, I, mom, leave everything in my trust. So we did a probate up in the county where Mammoth is. Final result was the judge signed a court order that said the trust owns it. So that's why you do it. It's a pour over will. It's kind of like a fail-safe. So on trust funding, your trust is either going to own it, be the beneficiary of it, or if you screw up, it'll get it via the will. But what's the problem with using the will? It's going to probate, which is what you're trying to avoid in the first place. So, last thing, what are you going to do about lawyers? You can go to the discount lawyers and good luck. Okay? You can go to the big firms downtown and they're going to hit you for big money. Okay? They just are. Solos like me are $1,500 to $2 grand. I run specials all the time. And I don't know, I think a reasonable day's wage for a good job is worth it. You can do it yourself, but the problem with doing your own estate planning is you're not going to know if you screwed it up. Your family's got to find out. So some people do their own bankruptcy, some people do their own divorce, and what will happen is the court will say you screwed this, and this up, fix it. You don't have that opportunity with estate planning because you're gone. So I think if there's really one time where you want competent representation, it's in estate planning. Okay? Malpractice insurance. Most people don't realize this. In California, I know it's a really consumer-oriented state, but there is no requirement that attorneys have malpractice insurance as of right now. So if you hire a lawyer and the lawyer screws up, if that lawyer didn't carry malpractice insurance, no malpractice attorney is going to take your case to sue that guy. Okay? And I want you to understand, I haven't had any claims in 21 years, and my malpractice insurance is $5,000 a year. And I've heard my buddies go through this. Family vacation to Hawaii, malpractice insurance. What do you do? Okay, I pay my malpractice premium because I don't want to get hit. Okay, and it's tough. I mean, writing that check is a bitch. Okay, it's big money. People say, why do lawyers charge a lot? Well, that's what our insurance is. So you got to look at that. So what I always tell people is I don't care if you're hiring the greatest lawyer on the face of the earth. Ask them what the name of their malpractice carrier is. You notice I didn't say, do you have malpractice insurance? Why? Because it's an easy lie. Ask them, what is the name of your malpractice carrier? Mine's Arch. Okay? Because if they can't tell you what it is, maybe they don't have it. Okay? And far be it from a lawyer to ever lie. It never happens. Okay? Experience and technical knowledge. Okay? I can handle a civil litigation case. It doesn't mean I want to do it. Okay? And what happens is I might run into trouble if I did it, so I don't do it. So make sure that when you're hiring a lawyer, make sure that they're knowledgeable in the area of law that you're hiring. A lot of people say, well, you only want somebody, that's all they do. I don't see how you can really make it into society if you're not practicing in a couple different areas of law. And I also wonder about your competency. I see bankruptcy attorneys, all they do is bankruptcy. I'm like, I can do bankruptcy in my sleep. Give me something, more technical or something really challenging, because that's, I just think that's how you really can tell a good lawyer if he can help you with pretty much every problem. It doesn't mean I'm going to represent you, but if I can't talk coherently about a particular area of law, then it makes me wonder. So, in any event, as part of the handouts, everybody got a questionnaire. If anybody wants a free consultation, just check the box and get the forms back to Jennifer, and I'll be glad to meet with you. And that goes for people up in Orange County. I travel up there too. And the only thing I ever ask, I'm glad to do all kinds of free stuff for you. You can email me, call me, whatever. The only thing I ever ask is that if you know people that can use my services, just please refer me. That's all I ever ask. Okay? So thank you very much, and hope you guys enjoyed the class.
Thank you.